Hi, I'm Steven Friedman.
Hi, I'm David Postalski, and we are both intellectual property attorneys at Gearhart Law. Today, we're here to talk about litigation strategies for trademark and copyright infringement.
Big question. It comes down to what the difference between trademarks and copyrights are. Trademarks are indications of source. That means a company's name, a company's logo. It could even be a distinctive sound that you associate with a company. So, infringing a trademark is confusing the public into believing you are associated with that source. A copyright is a work of authorship in a creative work. So, a book, a movie, those are all copyrightable works of authorship. And so, infringing on someone's copyright is copying one of those things.
Just to expand on what you said, the trademark infringement is all about whether there is another mark that might cause the likelihood or actual confusion with your existing mark. Whether it could also be, as Stephen said, a sound, a smell, a taste, or something like that, something that kind of appeals to the five senses of the consumer. Copyright infringement is also, as Stephen said, about the substantial similarities between your work, your copyrighted work, and somebody else's work, that third party work. So can you recognize your work in their work? Is it an exact duplicate of your work? There's a variety of factors that go into it.
There are basically two big legal remedies we're going to talk about. One, monetary remedies. When you're an infringer of a copyright or a trademark, there's a few different routes to tackling how you might recover damages from the infringer, or injunctive remedies, which is the court ordering the cessation of any kind of infringing activity.
Yeah, I guess more specifically, if we're talking about trademark infringement, it's the ability to stop that third party's trademark from selling the goods or the service that might be similar to your trademark and or collecting damages on that. On copyright, it's the same thing. It's asking the court to stop that infringing use, stop the publication of that infringing use, and of course, throwing in some sort of monetary damage as well. Both infringement and damages have to be proven in a court of law.
Okay, so to prove trademark infringement, the major test that is followed in federal courts in the United States is the likelihood of confusion test. Different federal courts have different factors, but it comes down to the basic question of when a consumer encounters the junior user or the infringing mark, are they going to be confused into thinking it is somehow associated, sponsored by, or is actually the original mark?
In copyright infringement, one has to prove the substantial similarity between the third party work and your work. That's a pretty hard thing to do because it's a very subjective type of analysis and it usually will fall to a jury. And so in layman's term, what it really comes down to is, can your work be identified in the third party work? Like, is there some sort of connection to it? Is it an exact replica of it? Is it something that's been inspired by it? There's a thin line between inspiration and infringement, and proving that could sometimes be hard.
Resolving a dispute before going to court is really key because it saves you a lot of money. There's a few ways of going about it. Usually, we will recommend sending the alleged infringer some kind of letter, a cease and desist letter or demand letter, telling them to stop infringing or to give up some kind of monetary remedy. And sometimes that can work. Sometimes you have to go to court to show you have some bite behind your bark.
So Stephen and I are both litigators, and as much as we enjoy going to court, we like to settle things out of the court. And one of the more popular ways of settling out of court is to go through some sort of alternative dispute resolution proceeding, like mediation or arbitration. Both parties would have to agree and submit to it, but we find that that's probably the best chance for both parties feeling like they're going to win and not having to spend a lot of money going through the federal court process.
Preventing infringement in the first place is also a great way of saving some money because then there's no dispute to spend money on. A great way in the first place is to get your work or your trademark registered. Getting things registered gets things on public notice. And so a lot of the time, for example, if someone's looking to start a new company, they might be looking to see if any existing company shares the same name, and they won't pick a name that's going to infringe in the first place. So that's a great way of getting ahead of things.
Other ways to do it, to bounce off what Stephen was saying, is mark your work. Use the copyright symbol, use the trademark symbol, use the circle R, the actual registered trademark symbol. And then, of course, the biggest strategy in protecting your work is finding out about infringers as quickly as possible. So in trademarks, you can start what's called a trademark watch, and you can find out what other people are filing or using. You get alerted, and you can then kind of cut the problem off, kind of nip it in the bud. Copyrights, a little bit more difficult to do that type of watching, but there are softwares that can basically identify if somebody's using your image or your work. So the strategies are out there, the services are out there. And so we would recommend that as soon as you register, watch, protect your property, look out for potential infringers, and cut these problems off as quickly as you can.
Yeah. The more you seem likely to protect your work and enforce your rights, the more likely a potential infringer is not going to be doing it.
Thank you for listening. We hope you enjoyed it. For more information, you can contact Stephen or I at www.gearhartlaw.com, or you can reach out to us on LinkedIn, and we're happy to provide more information. Thanks again.
Thanks.